New Jersey versus T.L.O. This Supreme Court case gives school officials the right to search a student's belongings if they have reasonable suspicion of a rule violation, which is a different legal standard than the probable cause police need. Historical context. The Supreme Court case New Jersey versus T.L.O. was decided in 1985. It occurred during a period of growing conservatism in the U.S. and significant changes in the Cold War. In the United States, the ruling took place under President Ronald Reagan's administration, which advocated for law and order policies. During this time, the nation was experiencing anxiety surrounding the war on drugs. This concern created political pressure to implement stricter measures for stopping illegal activities, with a main focus on addressing drug use and crime directed towards youth. Just 6 days after the ruling, President Reagan was inaugurated for his second term. Globally, the Cold War reached a turning point with the death of Soviet leader Konstantin Chernenko in March 1985. Case background. The 1985 Supreme Court case New Jersey versus T.L.O. determined if searches by public school officials on students are constitutional. The constitutional amendment is the Fourth Amendment. This amendment protects people from unreasonable searches and seizures. The case involved a 14-year-old student, referred to by her initials T.L.O., who was searched by a school administrator after being caught smoking in a school restroom. This search led to the discovery of marijuana and other drug-related items in her purse. The court was going to determine what level of suspicion school officials must have to meet before they can legally search a student. The defendant was T.L.O., who argued that the search was illegal. The prosecution was the state of New Jersey. Individuals involved. T.L.O. She was a high school student whose purse was searched by a school administrator. It led to her argument that her Fourth Amendment rights against unreasonable search and seizure were violated. Theodore Choplin, assistant vice principal. He was the school official who searched for T.L.O.'s purse after finding her smoking. He claimed it was justified based on her initial violation of the school rules. New Jersey. The state brought delinquency charges against T.L.O. and defended the search, arguing that school officials need a standard of reasonable suspicion rather than probable cause. Alan J. notes, he was the lawyer who represented the state of New Jersey. He advocated for the search legality and the reasonable standard for school administrators. Louis DeGiulio. She was the lawyer who represented T.L.O., arguing that the search was unconstitutional and that the evidence found should be excluded from court proceedings. Lower court history. New Jersey versus T.L.O. went to 3 lower courts before going to the U.S. Supreme Court. The 3 lower courts the case went to are the Juvenile and Domestic Relations Court of New Jersey, the New Jersey Superior Court, Appellate Division, and the New Jersey Supreme Court. The Juvenile and Domestic Relations Court of New Jersey found T.L.O. guilty, and the court approved the search through reasonable suspicion instead of probable cause. The vice principal had enough suspicion to determine she had cigarettes. The New Jersey Superior Court, Appellate Division, upheld the juvenile court's ruling, meaning they agreed the search was legal. The New Jersey Supreme Court overturned the lower decisions and the evidence could not be used. The court said that searching T.L.O.'s purse was unreasonable because possessing cigarettes was not illegal. So it was an unconstitutional violation on her Fourth Amendment rights. Supreme Court Justices. Here is the justices serving at this time, and it shows what they voted for. Supreme Court Decision. The case was decided on January 15, 1985. There were 9 justices serving on the court at that time. The final ruling was a 6-3 decision in favor of New Jersey. It justified the search of T.L.O.'s purse as constitutional under the new reasonable suspicion standard for the schools. This ruling was based on the Fourth Amendment, which protects people from unfair searches. The court decided that for schools, keeping students safe is more important than making principals meet the probable cause standard that police officers follow. Dissenting opinion. There was 2 different dissenting opinions in the New Jersey versus T.L.O. It was in 2 separate writings, one by Justice Brennan and another by Justice Stevens. They both rejected the majority's act of the lower reasonable suspicion standard for school searches. Justice Brennan argued that the traditional legal standard of probable cause must be maintained because the school's interest did not justify an exception to students' constitutional protections against unreasonable searches. Justice Stevens argued the search was illegal because the school official had no cause to search the purse for cigarettes, which were not illegal to possess. Impact on society. The case changed school law by allowing school officials to search students with reasonable suspicion instead of probable cause, like police officers have to do. This means school administration can search a student if they believe they have broken a rule. This gives the school more power and order. The long-term impact is less privacy for students at school. This ruling is still here today and is used as a foundation for all student searches today. Personal reflection. I agree with the ruling because reasonable suspicion should be sufficient to determine if a student is breaking a rule. As students, safety is the priority. Even if the case is a false alarm, it's better to investigate than to leave a potential threat unaddressed. I would rather schools be safe than sorry. What I find most interesting is the difference between the levels of certainty, the reasonable suspicion standard used by school staff versus the stricter probable cause standard used by police officers. The school standard is less demanding interpretation of the Fourth Amendment for the school environment.